Welcome to Ties That Bind, Law, Family, and Legacy.
Welcome back to Ties That Bind, Law, Family, and Legacy with Patti Garner. Patti is a Tennessee attorney who focuses on estate planning and probate, helping individuals and families make clear, thoughtful decisions about the future and avoid unnecessary complications down the road. With over 20 years of legal experience, she brings a straightforward, practical approach to these conversations. I'm Shameika Rhymes, and today we're talking about how to avoid probate in Tennessee and what strategies actually work and some of the biggest misconceptions that people have about the process. Welcome back, Patti.
Thank you, Shameika. Nice to be here.
Patti, what do people usually misunderstand about probate in Tennessee and what it actually involves?
Probate is a process that requires you to file and put forth a petition to the court to open an estate, to
Mhm.
get judicial approval to make the moves that need to be done to administer the estate. So, for instance, if we need to sell a house, um, you have to get judicial approval to approve the contract. Then you have to make a court appearance to release the funds and do all the different things that can be time consuming. And, if you've ever sold a
Mhm.
piece of real estate, you know that sometimes you're on a deadline. So a buyer makes an offer, they want a response within 48 hours, and you can't do that if we're walking through the probate process trying to get judicial approval. It's a difficult position to put your family in. And there's so many better ways
Mhm.
to plan your estate that would avoid that probate process by putting a trust in place and letting that be the foundation of your legacy and allowing them to not have to experience that process through the probate court. If the courts get involved, it can just become a very different animal than maybe what you wanted when you put it in your will, because
Mhm.
the judge could interpret it different than the way you had it written.
We're such a microwave society where we're like, I want it now. I don't want to have to go through this long process with deadlines and things. I just want it now.
That's right. That's right. And, I mean, in Tennessee, we have to be open for 4 months, which is shorter than it used to be. It used to be 6 months, but still that's 4 months of having to jump through the hoops and do the things and wait while the process goes through its process.
Well, what types of assets normally go through probate and which ones can pass outside of it?
So if you are operating either without a will or with a will, everything's going to go through probate. If you have set up a trust, then you can avoid probate with your real estate, with your businesses, with anything that you have funded into the trust and that the trust has protected. That's really the way to pass everything and not make it go through probate. Back to with a will or
Mhm.
without a will, if you have a 401k or retirement accounts, there are ways to pass that to your family members without having to go to probate because that passes outside the estate. Life insurance policies pass outside the estate, and that happens regardless, depending on how you have them directed with
Mhm.
your beneficiary designate.
Well, that was going to be my question if it's because of the beneficiary designations. So, how does a trust help someone avoid probate in Tennessee?
So it's a real clear process to where the trust is in operation. And let's say it's my trust, my estate. I pass away, then the trustee who succeeds me can immediately take over and begin doing the
Mm.
business of the estate. And if that means that it's time to sell property, if that means it's time to distribute property, whatever it calls for within my trust, they can begin to do that the day after I'm dead.
Well, going back to beneficiary designations, let's talk about that for a second. So, how do those designations, joint ownership, or payable on death accounts affect whether those assets go through probate?
So anything that's got a beneficiary designation that is appointed to a person. So if I have a bank account and I've named you as the beneficiary,
Mhm.
when I die, you just take my death certificate and go down to the bank and say, "Hey, she's dead. I need my money." It's the same
Mhm.
concept with the 401k or any other account that has a beneficiary designation. The thing is, sometimes people will say, well, mama left that and told Shamika to do the right thing with it. What does that mean? Well, what that means is you can take that and do what I ask you to do with it, but I'm not legally protected that you're gonna. So you could go down to the bank and clear the bank account and not share it with your siblings or not share it with my brother and sister like you promised you would. And there's nothing legally binding that would make you do that if I've designated you on the beneficiary.
Yeah, because I guess some siblings have different definitions of do the right thing, of course.
And you find that out most of all when you're in probate court.
So, what are some of the most common probate avoidance strategies that people think will work, but then they find out it's creating problems?
So I see them put their children on their bank accounts. I see them add their children to the deed of their house. Both of those are problematic because we have potentially, hopefully, adult children running around out here. I hope nobody's
Mhm.
awarding those things to minor children. But I've seen that happen. So adult children go out and let's say you have a child who is a bit of a troublemaker and gets into some
Mm.
trouble or has a debt issue or a gambling issue and somebody sues them to recover the money that they've spent um, or borrowed or whatever, and then they find out that their name is on your house or they find out that their name is on your bank account. Well, they're going to come levy or they're going to put a lien on your house, and you ultimately are going to pay for that child's mistakes. The other problem with putting your child's name on the deed, and a lot of people do it because they think, oh, I'm circumventing probate and I'm doing it without having to go to the expense of the estate planning attorney. But what happens is, let's say your mom bought a property back in, and she's held it for 20 years. And let's use round numbers. She bought it for $100,000. Today it's worth $500,000. When I put that child's name on that deed, now that child is going to be taxed as though that child got that property for $100,000. So when they sell it, they're going to sell it and they're going to pay taxes on the $100,000 number as opposed to the $500,000 number. So it's really unfair to the child when there is that tax protection for them that they could avoid.
Makes sense. So, where do you see families unintentionally create probate issues without realizing? I know you just gave an example, but is there any other ones?
You know, when we don't sign the forms or we don't go and sit down with an estate planning attorney, nobody wants to talk about planning the end. You know, and I
Hmm.
know when you think about it that way, it doesn't sound fun and it's not sexy and it's not all the things. But the truth is, it really can be a fun way to demonstrate this is the way I want to take care of my people. Well, I encourage everybody to contemplate, you know, whether or not you want a will or you want a trust, depending on where you're at in life and where you're headed, and then
Hmm.
make those decisions, but put a plan in place. Because if you don't put a plan in place, then from my perspective, you're just setting yourself up for failure, or you're setting your family up for failure because they're not going to have the things that they need, or it's going to be a battle trying to get through probate court.
Well, Patty, can you walk us through a situation where you've seen where someone believed that everything was set up to avoid probate and things just did not go the way they expected?
Yeah, unfortunately, I've got one of those right now. Large family, lots of siblings. Mom and dad had put a trust in place. They did not do the necessary steps to fund it properly.
Mm.
So the life insurance did not get added into for the beneficiary, didn't get added to the estate. The bank accounts did not get transitioned over. There were some vehicles and some other just minor things, and sometimes we have to deal with that, just minor
Mhm.
things out, in probate, even though you have a trust and things have been done well. But in this particular instance, they had a really difficult time dealing with the bank institutes and the life insurance policies.
Wow.
So, and it's frustrating,
Mm.
and they come in with their estate book and they're sitting here and they're like, "But we have a trust. Why do we have to do
Mhm.
this?" And it's like, "Well, I'm sorry. Mom and dad didn't finish those extra steps."
Right.
So
Wow.
it happens. And I would just encourage everybody to take a look at, if you do have a trust, then take a look at, where you're at. And that needs to be done, in my opinion, it needs to be done at least every 3 years.
can change like tomorrow or even the same day. Wow, yeah.
because life changes.
Well, are there situations where probate is actually more manageable than people assume?
It can be if the siblings are not fussing, if there's no additional heirs, if there's not a lost heir. It can be very manageable. It can be a pretty straightforward process. The concern is always, but will it be? Because what's gonna, who's gonna come out of the woodwork? Who's gonna say, "Oh no, I'm related to her or I'm related to him, and I want my fair share."
Yeah, actually, that reminds me of something like I was talking with someone and she said when her father passed, now there's all these 10 extra siblings that nobody knew anything about that kind of came with their hands out. And, she's like,
They come forward, they want their part of the share, and without a proper structure, it's difficult to deal with.
so what does effective estate planning look like for someone who wants to make things easier for their family and minimize probate complications later?
From my perspective, that is a 1 hour meeting with an estate attorney to formalize what your plan
Hmm.
is, and then a second meeting where you do a full strategy planning session where we talk about what are the assets, how are we going to layer them so that you are protected, so that your kids are protected, your grandchildren are protected. What do you want your trust or your plan to effectively handle so that we can put it all into play? It's actually a really fun design session. And I know that's kind of weird. I have a girlfriend who loves to design houses and she loves to pick colors and do all the thing. So when I think about designing a plan, that's kind of what I'm
Hmm.
feeling is this is fun and it's protection and it's
Wow.
it's a way that you can look forward to, sharing and gifting things to your family and and leaving your legacy because I like to design that to set up your structure so that you're leaving it for a legacy for your grandchildren's children if possible.
Wow. Well, thank you so much, Patty, for breaking this down for us today.
Yeah, absolutely. It's always good to see you, Shamika.
Good to see you. Well, that is it for today's episode of Ties That Bind Law, Family, and Legacy with Patti Garner. If you have questions about your own estate plan or you want to make sure that you're making the right decisions for your family, you can reach out to Patti Garner at Garner Law Firm by visiting pattibgarner.com. Thank you for listening, and don't forget to like, subscribe, and share this episode with someone who might find it helpful.
Y'all give me a call and let's plan your legacy.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.